Hello guys, and welcome to another episode of our civil litigation mock trial course by the DECO Daniel School of Law. And on today's episode, we are discussing two drafts. The first being the Notice of Preliminary Objection, and the second being motion on notice to challenge the jurisdiction of the court. And these drafts are for our Module 2. Module 2 on jurisdiction of the court, civil jurisdiction of the court, right? In this class, we have to understand what we mean when we say jurisdiction, which has been discussed in this module, right? We understand what we mean when we say jurisdiction, what courts have jurisdiction, what is the enabling law per court regarding jurisdiction. Now, if peradventure you enter a courtroom and then somebody brings a matter that you know is not within the jurisdiction of this court, you know the law, you are the law yourself, you are the bar, you are the bench. You know that this matter is not within the jurisdiction of the court. What are the ways that you can tell my lord, you can't sit on this matter. This matter is not within your jurisdiction. What are the ways you can let my lord know? Right? We have three ways by which this can be done, although there are four, right? There are four, but the fourth way is seldomly used, right? But there are three ways which is more often than not used. Three ways. The first is that you can make an oral application to the court that, my lord, you cannot hear this matter, blah, 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 blah. You are like letting the court know. It's called viva voce, right? You are making an oral application to the court. Now, the court seldomly grants oral application challenging its jurisdiction, except it is glaring. It is so glaring that, Okay, so one day now, I was appearing before a magistrate court at Ogba. Right? Before my case was called at that magistrate court, there was a case, it was a criminal case I was going for. We had the defense. Now, there was a case there, and then in that matter, right, I think that somebody who is a tenant was supposed to pay his landlord now a female, right, and then he did not pay. So he didn't pay for a while. And I think that when the landlord challenged him, that he should leave our house and stuff, the guy was like, who you be, blah, 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 and challenge, he want to show, Lagos life now, want to show that he was gone around there. If you don't understand Yoruba, wants to show that even you sabi violence for violence, something like that. I don't know the defense of the guy. I don't know the fact of the case, because it was when the woman came to court, and then the judge was like, what's the problem? Why is this man here? Magistrate court is more or less informal, right? So the court was like, why is this man here? And then the woman was like, I am the landlord. He is the tenant. He is owing money. I said, make it come out. He no come out. He can't beat me. He can't kidnap me. The moment my lord heard, it's at the magistrate court, so he's no longer my lord. And since it's Lagos, it is your honor. If it is other magistrate court in other states, it will be your worship. Right? So, since it's Lagos, it is your honor. So, but we use my lord, regardless of the fact that we ought to use your honor. But please, for the sake of bar finals, it is your honor. For magistrate court Lagos, for magistrate court of other jurisdiction, it is your worship. Now, so my honor in this case now said, hey, stop there. Because if you say further, right, it takes this matter from, the hands of magistrate court. Magistrate court cannot listen to cases that its punishment is what? Is capital offenses, right? And in this case now, I only say, tell me what happened. And all of a sudden, you are already telling me that you were kidnapped. Bawu. Stop. Let me go back to the charge sheet before me and see what is there. Now, the reason I'm bringing that case to you is for you to understand that even the magistrate is so glaring that even the magistrate knows that, at this point, because if you bring a charge sheet and that charge sheet has kidnapping, right? Kidnapping, which is not within the jurisdiction of the magistrate court because it is a capital punishment, right? And capital punishment, magistrate court cannot hear it. The other party does not need to file anything, frankly speaking. An oral application will do in that regard. My Lord, the substance of this matter is murder. The substance of this matter is what? Kidnapping. My Lord don't tell you to go and file application, because my Lord already knows. Even my Lord cannot move on, because my Lord knows that. So there are certain times oral application can work, but it is not all the time. 99% of the cases, especially in civil litigation, my Lord will tell you, go and file an application. You can't come by oral application. Right? Now, when we are talking about the application to file, there are now two applications that you can file before my Lord. You can either file a notice of preliminary objection challenging the jurisdiction of the court, or you can file a motion on notice supported by affidavit and written address challenging the jurisdiction of the court. And those two things are why we are here today, to learn how to draft them before my Lord and file them. Do you get my point? How do you draft a notice of preliminary objection? And also, we need to understand, when do we use these two things? We use a notice of preliminary objection when it is clear that we want to argue on point of law. Right? When I was teaching you my pleadings class, I told you that one of the functions of pleadings is that from the pleadings, we can determine whether or not the court has jurisdiction. This is a civil litigation class. So when a claimant has filed his writ of summons and then he has accompanied a statement of claim, we go to the statement of claim. We want to interrogate it. Is this matter, this claim that this person is shouting about, is it such that it is within this court's jurisdiction? If it is not within the court's jurisdiction and it is a matter of law, then you can use a notice of preliminary objection. But if it is something that the facts are contentious, we are not certain on the fact yet, then you can use a motion on notice. Do you understand? Why? Because a notice of preliminary objection only has the notice and a written address. It does not have an affidavit where you are supposed to depose to facts. While a motion on notice has the motion paper, the affidavit where you are supposed to depose to the contentious fact, and a written address. Do you understand the basic difference? So now let's go to the drafting. Like I've taught in my classes, right? And I always teach. You start with the heading of the courts, right? In the High Court of Lagos, in the Lagos Judicial Division, holding at Lagos. Not holding in Lagos, holding at Lagos. And look at the spelling of the holding. It is not ing, it is en. Okay? Now, if you want to know the court that you are supposed to take a matter to, then please go and watch my jurisdiction class, Module 2. Watch the jurisdiction class on Module 2. Then in all your application, you know that this is notice of preliminary objection, which is so much like a written address, right? We'll talk about some of the differences. In all your application, you are supposed to have your suit number. Then after that, you have between. Then you now tell us the parties. You have your between, then you tell us your parties. How do you properly draft your parties clause? Please go and watch my parties to a civil suit, Module 3, for how to properly draft parties. Right? If it's a child, how do you draft? Representative capacity, how do you draft? If it's a donee of power of authority, how do you draft? If it's class action, what do you do? All those kind of things, I have already taught them in the class on parties to a civil suit. Right? So we already have that. Now, I also told you that when you are bringing an application, notice of preliminary objection is an application. You must, label each party accordingly. Whoever brings the application is the one that is the applicant, while the other party is the respondent. As the case is here, we now have an additional naming, quote and unquote, of this party. Who is the applicant? Is the defendant / applicant / objector. Right? For the sake of law school, please copy it and paste it for them like this. Some draft book will not use objector. Some will just say defendant / applicant. But please, for the sake of law school, use defendant / applicant / objector. Now, if you want to cross-check again and be very sure, you can go and ask your lecturer. Now, depending on what your lecturer say, you can now follow that. Because I believe that the objector is what differentiates a notice of preliminary objection from a motion or notice. That's one of the distinguishing factors, because you cannot have objector for a motion or notice. Do you understand that? So, we have the defendant / applicant / objector, and we have the claimant / respondent. The claimant can never be an applicant for notice of preliminary objection. It doesn't make any sense, right? You can't be a claimant and be an applicant, because now you carry the matter go court. Now you walk on the object to the court, say the court don't get jurisdiction. Does it make any sense to you? So it always has to be the defendant / applicant / objector who will object to the jurisdiction of the court. Now, to take it a step further, we now have the head, the notice of preliminary objection. In our previous draftings, we have thought about, just the heading, motion ex parte, motion or notice. Motion ex parte, motion or notice. But in this case, we have a PO, notice of preliminary objection, right? Note that preliminary objection, this notice, is only used to, challenge the jurisdiction of the court, and when you are challenging the jurisdiction of the court, strictly speaking, on point of law. You are challenging the jurisdiction of the court, strictly speaking, on point of law. Now, after that, you have the broad pursuant to. The broad pursuant to, you are bringing it under three things. When you are bringing notice of preliminary objection, you must bring it under three things. Number one, the constitutional provision or any other law that provides against the jurisdiction of that court. Do you understand that? It is not the one that provides for the jurisdiction, it's the one that provides against the jurisdiction. So in this case, this matter is brought before who? The High Court of Lagos. Then we are bringing section 251, which is the Federal High Court section, the section that creates the Federal High Court and gave it jurisdiction. Section 251. So it is the section that is against that case that you now say, brought pursuant to section 251. My Lord, go and read section 251 to see that you don't have jurisdiction. And also, order 43 of the civil procedure rules, which is through which we have all applications brought and under the inherent jurisdiction of this court. So there are three things that you put in your PO when we are talking about the broad pursuant to section. The first one is the constitutional provision against that court, showing that the substance of the suit is in another court. You see why you need to learn your jurisdiction very well? So that when they ask you that, okay, draft a notice of preliminary objection, you know that you need to know what court ought to have jurisdiction, so that you can put the section that gives that court jurisdiction in your broad pursuant to. Right? So broad pursuant to section 251 of the Constitution, and order 43, which is the second thing, the general order that provides for all application to be brought, order 43. And what else? And under the inherent jurisdiction of the court. Those three things must be in your broad pursuant to. The fact that it is section 251 now does not mean to always be section 251. Oh. It depends on the subject matter. Oh. If you are drafting in the magistrate court, for example, you will write in the magistrate courts of Lagos State, in the Lagos Magisterial Division holding at Lagos or something like that. Right? Then you go to your parties. Now, they are saying, okay, notice of preliminary objection, for example. You are now saying broad pursuant to. Are you going to say broad pursuant to 251? Is it 251 now that talks about, let's say we're talking about kidnapping and all that? Is it 251 that talks about kidnapping? No. So therefore, you have to broad pursuant to, quote and unquote, you have to bring it pursuant to the section that gives the other court jurisdiction. why 251 is used in this case. So you are bringing pursuant to three things: to the section that give the other court jurisdiction, to Order 43 of the High Court of Lagos State Civil Procedure Rules 2019, and within the inherent jurisdiction of the court. Those three things. Now, we go to the body. And then when we are going to the body, right, there is something that makes this significantly different from a motion on notice. Why did I say that? Because when we're talking about a motion on notice, we have take notice that this honorable court to be moved on the dash day of dash 20 dash at the hour of 9 o'clock in the forenoon or so soon thereafter, as counsel for the claimant applicant may be heard praying this honorable court for the following orders or for the following reliefs, right? But in this case, what we have take notice that at the hearing of the above suit, the defendant applicant intends to challenge the competence of this suit. See, you have to cram this thing, my dear brothers and sisters, my dear learned colleagues, or learning colleagues as the case is, right? You have to cram it. Take notice that at the hearing of this suit, the defendant applicant intends to challenge the competence of the suit and will be heard praying this honorable court for an order striking out the suit. One thing that is not there is no in the forenoon or so soon thereafter, there. Do you understand? What we have here is that take notice that when we want to hear this suit, the defendant won't challenge the competence of this suit, and we won't make the court strike them out. Three things. So you are saying take notice. As at the time when we won't hear them, number one, the defendant won't challenge the competence of the suit, number two, and we won't make you strike this matter come out, number three. Did you hear that? So take notice that at the hearing of this suit, the defendant intends to challenge the jurisdiction of this court or the competence of this suit and will be heard praying this honorable court for an order striking out the suit. Those three things. Or preliminary objection. That is the essence of the preliminary objection, to strike out the matter, because you know that the court lacks jurisdiction. And take further notice that the grounds on which the defendant applicant intends to rely are as follows. A, that the action is incompetent as the subject matter is exclusively within the jurisdiction of the High Court, and this honorable court lacks the jurisdiction to entertain the matter. So there are two things. After you have told the court, yes, take notice, you will not tell the court again, yes, take further notice. I can remember the first time that I was drafting a preliminary objection at law school, right? We didn't know anything. We just entered law school then and they gave us an assignment. We have not even attended class. I can remember that I said, take notice first. Then I now said, take further notice. Then I still said, take final notice. It was as if I was daring the judges. So I said, take notice, take further notice, then take final notice that so and so. I don't know what draft book I used that time, but it was one very misleading draft book. So I don't want that kind of thing to happen to you. So you have take notice, then you have take further notice, then you have not take final notice. Please, you don't have take final notice. You just have take notice and take further notice. Do you understand? So don't be like me that had take final notice. But that was at the early, I think it was January. We wrote our exams in December, and that was January 20-something, right? Because I remember that we resumed January 16th. So it was January 20-something that I made that mistake. So, of course, I had enough time to rectify it. So please. So now, when you are saying take further notice, your take further notice is the grounds. What grounds? So take further notice that the grounds on which the defendant applicant intends to rely as follows. So what are the grounds upon which you are intending to rely? So number one, that the action is incompetent as the subject matter is within the exclusive jurisdiction of the Federal High Court, and the Honorable Court, that's number two, lacks the jurisdiction to entertain the suit. So once you know that, okay, if I'm going to draft a notice of preliminary objection, I will start with the heading of the court. He has to be in the proper court, that's the court that instituted the matter. Then I must have suit number. Then I must have what next? I must have the parties, right? The claimant and the defendant. Because it's an application, one has to be respondent, one has to be applicant. Because it's a notice of preliminary objection, one has to be objector. Please, there is no objectee. There is just objector. Don't say objector/objectee, whatever it is. So one has to be objector. Then by implication, one is defendant/applicant/objector. Why? Because it's a notice of preliminary objection. Then after that, we then write the heading, notice of preliminary objection. Then we have brought pursuant to. You bring pursuant to the enabling law of the other court that gives the other court the jurisdiction for this matter. Not the law of this court, because this court does not have jurisdiction. You bring the enabling law of that other court. Then number 2, Order 43, because it's in the High Court of Lagos State. So all applications should be brought under Order 43 and in the inherent jurisdiction of this court. So 3 things that you are doing. Right? And I've taught you what those 3 things are. Then you now say, take notice that at the hearing of the suit, the defendant applicant intends to challenge the competence of this suit and will be heard praying this honorable court for an order striking out the suit. So 3 things. Take notice that at the hearing of this suit, 1, the defendant intends to challenge the competence of this suit. 2, and shall be heard praying this honorable court to strike out this suit. 3. So you have to put those 3 things there, right? Take notice that when we want to hear this suit, I will challenge the competence of this suit and I will ask you to strike out this suit. 3 things. Then after that, you now take another step. Take further notice. There is no take final notice. There is take notice and take further notice. So your take notice is you are informing the court what you intend to do. And then your take further notice is that you are informing the court the grounds upon which you intend to do what you want to do. So what are your grounds? So take further notice that the grounds on which the defendant applicant intends to rely are as follows. Then now state your grounds, right? That this matter or this action or this suit is within the exclusive jurisdiction of the Federal High Court. And number 2, that this court does not have jurisdiction to hear it. Simple and short. Can you see that drafting is not hard? Drafting is actually not hard. It's one of the most easy things that you can do. Do you understand? And then you then take a step further. You must write your date under. Please, every process must have a date under. So this is an application. After everything, you have your date under. Then you have the signature by the lawyer, right? The part for the signature, which is on the right-hand side. Right? You put your dash sign, then you write your name, then you write your firm's name, then you write who you are representing, and then the address, email, and phone number. Please do not forget. Please do not forget this way to write. Number 1 is your name. Number 2, your firm's name. Number 3, who you are representing. Number 4, your address. Number 5, your email. And number 6, your phone number. Those 6 things, don't forget them in that order. Please. And then you have for service on or on notice to. Anyone will work. For service on or on notice to. Then you put the name of the lawyer, the firm of the lawyer, that is the claimant respondent, and the address of the lawyer. If you have the phone number and email of the lawyer, please add it. If you have the phone number and email of the lawyer, please add it. And that is where we end our class for today. In our next class, we take it a step further. We are going to talk about the 3rd way by which we can challenge the jurisdiction of the court. You know, I told you that the first way to challenge is orally, right? But my Lord is likely going to tell you to put it into writing. Except it is so notorious, that kind of matter is so notorious that you don't need to put it in writing. Even my Lord cannot continue. Right? Like the example that I gave earlier, kidnapping in a magistrate court. My Lord said, stop it there. I can't even continue if you mention that. So I have to go back to the charge sheet and assume jurisdiction based on what is in the charge sheet. Do you understand my point? Right? So We know that there is oral, we know that there is preliminary objection, and today now we know how to properly draft a notice of preliminary objection. In our next class, we will then take a step further by learning how to properly draft a motion or notice challenging the jurisdiction of the court. I will see you in my next draft class. Please have a very wonderful day.